For those that don't know me, my name's Stephen Knight. I'm the founder of Pimento and the Chief Executive Officer. And this is part of a series of events we run across the year for members and non-members on things that are critically important to the marketing industry, agencies and clients alike. This is pretty much universal. This is something that's going to impact all of us. So I'm really, really pleased that we've got an expert on today's webinar, Heidi, who's joined us from Reality HR, been Pimento members for some years. The session today will cover off how you need to prepare and what the employee rights bill will mean for you. There's still obviously detail around it, and I know there's like to be further changes perhaps in the forthcoming event, as I should call it, in November when we go through the second budget. But anyway, Heidi, her background is she's a head of learning and development at Reality HR. She leads a team of expert trainers and ensures every session is both tailored and insightful and impactful. So I think you'll enjoy her presentation. She has a diverse background both in hospitality, retail and manufacturing, so she brings a lot of practical real world solutions through her training and through her exercises. And for those that don't know, Reality HR are a outsourced HR provider that work with literally hundreds of businesses, small and large, across the UK, and have a specialism in the marketing category. So they're used to working with creative agencies and marketing brands alike. There will be a copy of the presentation sent to you afterwards. And unless you haven't done so already, there is a checklist. It's kind of a little survey that we would suggest that you do. If you haven't already done it, we'll send you the link afterwards, or the link will be put into the chat box in a second. Do download it and complete it, because it will give you a really useful checklist as to what you as an organisation need to do ahead of these changes. So we're going to film it, so smile throughout, and we'll share this afterwards with any colleagues. You can please pass it on to them. But I'm going to shut up now. I'm going to hand over to someone who knows what they're talking about, and we'll invite Heidi onto the screen. There she is, and she's going to take you through a presentation, but there'll be plenty of opportunities for Q&A. And in fact, actually, if you have got questions, rather than leave it to the end, do use the little chat at the bottom, and I'm sure I'd be very happy to take questions as we go through it, because it's designed to be a interactive conversation rather than a presentation. So here we go.
Brilliant. Thank you so much. I'm a bit nervous being called an expert twice, I think, in that introduction, but I will do my best to live up to that intro. Thank you so much, Stephen. I've met a few of you before. I know I've been on some of these sessions and talked to you about various topics. Some of you may have heard we were talking about the Employment Rights Bill earlier in the year with Alistair from Harrington Carmichael. I'm here on my own today, so hopefully I can field any questions that you've got. I will absolutely do my best, and anything we can't answer now that I don't know the answer to off the top of my head, we will come back to you later. But as Stephen said, please do ask any questions as we go. It makes it much more interesting for you all rather than just my monotone for an hour. Stephen mentioned the checklist, and absolutely what we're hoping for is that you've got a copy of that checklist available to you. Maybe you've managed to download it, or you've got it open in front of you. And as I talk through some of these areas and some of the topics, you maybe want to just make some notes straight away into the checklist of things, actions you're going to take after the session. And then, of course, areas that you don't know the answer to, you need to go and look into within your organisation, within your agency. You can go and do that after the session. We are very, very happy to take any questions from members after that. Once you've completed that checklist, we would be very happy to talk you through what that looks like for a plan, how you can kind of get yourself up to speed. The session today really is in two parts. It's a bit about what is the current legislation, what are the current compliance requirements for all employers, no matter how big or small. So this is where the checklist is really useful. What are you looking at? Are you up to speed? Are you ticking every box right now? And then the second part of the session, I'll be talking a little bit about what the changes that are coming in the Employment Rights Bill, as far as we know them, and I'll give you an update on where we are with the roadmap for implementation. Thank you. I've seen the link for the checklist is in the chat. So if you haven't downloaded that yet, you can hopefully grab a copy now. Stephen, if you're happy to just shout at me if there are any questions come into the chat that's sort of that I need to stop at, and then I can, just interrupt me with those if they come into the chat. Or again, anyone, please feel free to unmute and just shout at me. I love an interruption, so please do.
Also, you can raise your hand. There's a raise your hand button somewhere, I think.
Yeah, absolutely. We'll keep an eye on all routes. Please do get involved though, if for any route at all. Okay, so why are we talking about compliance? Well, why does it matter? Compliance is obviously a legal requirement. This is what we mean when we talk about compliance. Are we complying with all the legislation and regulations that govern employing people? Even if you've only got one employee, I appreciate this can feel like a bit of overkill for some of for those very small organisations, but the legislation exists that covers one employee, 100, 1,000. It doesn't matter. There's no difference in that implementation of the legislation. You'll all be absolutely aware of some of these headline legal requirements: Health and Safety at Work Act, the Worker Protection Act much more recently. There's a whole raft of legislation in between 1970 and now. And of course, the upcoming Employment Rights Bill that will amend a lot of that existing legislation. Breaching these, failing to get this right, hefty financial penalties, as well as the potential for civil and criminal prosecutions as well, particularly for those of you that are directors of your agency or your company. So we want to get this right because the law says this is what we should be doing. But actually, there's some other really valuable reasons for getting the compliance part right, so getting our foundations right. When we are treating people with fairness and transparency in the workplace, we are going to see, we see increased productivity, performance, and engagement from people. Employers who feel that they've been treated fairly and who they can see your policies match what the government website says, for example, or what ACAS says, for example, they are going to feel automatically more engaged, more bought in really to your values of your organisation. And I think you'll all be aware that awareness is increasing. People know more about their rights now, and so trying to hide any of their rights or trying to keep things sort of tucked away, we see it backfire because people know their rights. I mean, that maybe they're getting their employment advice from TikTok, so they might not know their rights fully accurately, but there is a lot more conversation in current times about our rights as employees, as workers. So people do know this stuff, and so our advice is really to be absolutely transparent with your teams. Why would you try and hide something when they can go and find out elsewhere? That is crucial for your existing team, but also for your reputation as an employer. We know that recruiting is a challenging time. We know that people are very keen, shall we say, sometimes to talk about an ex-employer when they move on. You'll all be aware of Glassdoor, the TripAdvisor for employment. And so making sure that we're doing all these basics right, as a bare minimum, of course. We don't just want to do compliance, but making sure we've got the compliance part right is so valuable. It's so essential really for this productivity, engagement, and our reputation. So I'm going to talk through, like I say, some of the aspects of compliance that we need to be thinking of, and some of this might be things that you're absolutely sure you've got ticked off, and that's brilliant. But we come across many organisations, many businesses who have got a contract of employment for their employees, but it was written 10 years ago and it hasn't been looked at since. That's a really common situation for lots of businesses to be in. And actually, there have been all sorts of changes to case law in that time. And every time anything big hits the news or hits the headlines, the lawyers suggest we add additional clauses to your contracts. Now, this is boring stuff, I know. I'm really sorry. This is the absolute fundamental. The written contract of employment between the company, the agency, the business, and the employee is the cornerstone of everything, really. And making sure that they are updated, that they're current, that they're fit for purpose, that they suit your organisational needs, as well as meeting the legislative requirements. Are they fair and reasonable? Are they transparent? Again, there's that word, but also are they consistently applied? Any of you that have ever had a conversation with anyone in HR will know one of our favourite words is consistency. So are we applying all our terms, all our rules consistently across the organisation? Because more often than not, when we get complaints of discrimination or complaints about harassment, it's often that policies have been applied inconsistently. So and so was allowed to work flexibly and I'm not, or so and so was allowed to get a bonus and I didn't. So it's this lack of consistency that causes those challenges for a lot of us. So it's worth going back to your contract and just checking how long ago was it written? Has it been checked recently by a legal or HR advisor? And does it still meet what you want as a company? Now, things like working from home or hybrid working have been, by necessity, just appeared in 2020. We all know what happened. We all had to scramble to make that happen. If you've got people that have been working from home since 2020, and you haven't updated their contract to reflect what you actually want, you're going to find it very difficult if you want to change that reality. Written terms and conditions are not always the trump card over custom and practice. So it's worth looking at not just the legal changes, but any operational changes as well that you want to make. So we can help, obviously, with new templates. We can also help with updating terms for your existing employees, if that's what you choose to do for operational reasons or for any of those legal advice. And I would say that if you are going to consider changing terms and conditions for existing employees, do it now. Do it as soon as possible, because you'll hear why as we get towards the end of the presentation this morning and we talk about fire and rehire, which is actually a headline grabbing name for changing terms and conditions. So if you want to change terms and conditions, I would suggest getting some advice and making that process start sooner rather than later. Everything I've just said about contracts also applies to policies. What does your employee handbook look like? Do you have a handbook or a set of policies that's available, published, people know where to find them, and again, that they're current in terms of meeting legislative requirements, but also current in terms of meeting your operational activities? If your business has changed substantially and you haven't updated your policies, maybe now's the time to have that look. Something that's come up very recently, this is a live employment tribunal case that we've just seen, is where an individual was dismissed actually for gross misconduct. The company decided that the behaviour was gross misconduct. When the individual took that employer to an to employment tribunal for unfair dismissal, the tribunal found that actually it was unfair because the activity that the individual was engaged in wasn't listed in their disciplinary policy as an example of gross misconduct. It wasn't referenced anywhere as an example of misconduct, let alone gross misconduct. So a disciplinary policy template will probably have some examples of the types of behaviour that would constitute misconduct and gross misconduct. But it's really important that if you have anything specific or relevant to that individual's role or to your company or to the industry, you have to have that labelled and specified there. The particular example I'm talking about was in a hotel and the individual had fallen asleep on the night shift. Now, if you've got night shift workers, it's quite it seems to me that it would be quite reasonable to expect putting a reference to not sleeping on the job in there. That might not be something that you guys need to write into your contracts. It's certainly not in our standard policy around sleeping on the job. But if you've got people working night shifts, then it's definitely a relevant example to include. So just think about what are the specific examples that would be really important to you as an agency, as an industry, and make sure that your policies are up to date. And I mentioned published and accessible. Do all your staff know where to find them? And this is going to be even more important when we come on to things like talking about grievances and harassment. So do your staff know where to find your dignity at work policy, your bullying and harassment policy, your equal opportunities policy? And do they know where to find them without coming and asking their line manager for them? Because if they're being harassed or feel they're being harassed by their line manager, having to ask their line manager for a copy of the policy is likely to trap you in an indefensible position as an organisation. So published, accessible are really important points. Okay. So as I say, this is the boring stuff, but this is the absolute foundation. This is the absolute foundation of our employment relationship with our staff. What comes next? Well, also real boring stuff, and I'm not going to go into too much detail on any of these, but you'll see on the checklist, we've got some questions, some searching questions for you to ask yourselves. Do we do all these things? Do we meet all our requirements? So we're looking at page 6 and page 7 here for immigration and the right to work. Do you have evidence of every individual's right to work? Do you have that either in terms of a copy of a passport or from a share code if they've evidenced their right to work online? The checks on the right to work, so having to check and having to keep this evidence came into law back in the early 90s. So it should be something that we're doing just as custom and practice, that we automatically check a right to work when we appoint a new employee. But actually what's often slips through the net is people who've been with us a long time, and we can't just assume that they've got the right to work unless we've got that evidence on file. The fines for not being able to evidence that you've done those right to work checks are substantial and increasing. I'm not going to really talk about health and safety at all. I'm a HR expert, as Stephen called me, but I'm not a health and safety expert. But making sure that you've considered health and safety. Have you, again, on page 6, a series of probing questions. Have you got a policy in place? Have you got an appointed person? Have you got a first aider if you need one? Have you got all of the things that are going to be relevant for your organisation? And if you don't know what you need, now's the time really to go and get that advice and make sure that you're putting those practices into place.
Heidi, a question if I may, it's coming from, just saying realistically, how often should contracts be updated?
Contracts of employment?
Yeah.
Yeah. It's a tricky one, because the lawyers will give you the answer that every time there's some sort of new case that sets a new precedent, they would suggest you need a new template. Pragmatically, it's probably not that frequent in our view. And updating your template for new starters is different from updating the existing contracts and terms for all of your employees. So from a legal perspective, there's nothing that says you have to create a new contract at any point in time. So there's no actual law to force you to do that. It's more about knowing your business. So if things have changed operationally within your business, then that would be a good time to update the contract for everyone, and ask them to sign a new version. Or if there's a specific case that's really relevant to your organization or your industry, then that would be a good time as well, or a good trigger as well. Lots of questions around post-termination restrictions, PTRs. If you have senior people in your organization, and you don't have bespoke drafted PTRs for them for when they move on, then you might want to consider actually updating those. They're hard to enforce, but for the senior people, those that could do a lot of damage if they leave your business, if they take a client base with them or could poach your staff, those are the people that you're going to want to make sure that you've got really robust PTRs in place for them. So there isn't really a one-size-fits-all answer to that question about contracts. So I would definitely say it's worth checking your templates still fit for purpose at least annually, but going out and asking everyone to re-sign a contract, you probably don't need to do that unless there's some organizational change that you want to catch up on.
Thank you.
Super. Okay, and just on that point as well, reviewing your policies and making sure they're still fit for purpose is probably also an annual activity. If you have policies around family-friendly leave, so maternity, paternity, shared parental leave, adoption leave, the right to time off for any sort of family crisis, those actually change quite often. The law around those changes quite often. So if you've got fully detailed policies in your handbooks around any of those topics, if you do have anyone asking for any of those time off or to take up any of those rights, do make sure you're checking the gov.uk website for the latest versions, because your policies are likely to be out of date. We've seen changes to parental rights, I think, for the last 3 years in a row. Small changes, small tweaks, but that's another thing that's probably gone under the radar, that you might not have updated your policies. So do make sure that you're just checking gov.uk for the very latest versions. And again, there's a whole raft of change coming around that, again, as part of the Employment Rights Bill. So it's not to say necessarily you have to rewrite your entire handbook every time the law changes in some small way. But for those of you that have worked with us, I'm not sure if there's anyone on the call, we work with, as Stephen said, about 400 companies at the moment, and those companies that have a sort of a signed up retainer with us, we will automatically update your handbook and policies with any of those statutory changes. But if you don't have that relationship with a HR company, then you will need to be double checking gov.uk to make sure you're up to date. And I'd say that a few times. Gov.uk, the site's brilliant. It's really well written. It's really easy to access. So actually, it's good advice for you as employers. But it's also, remember, where our employees are going to be going to look for information. So we need to make sure we, as the employers, have got all of that information to hand. Okay,
Hi,
yeah.
can I ask a question? Hi, morning, Stephen. PTR, that's has that changed much in the last 10, 20 years? Is it still 6 months? You're probably okay with a year, it's a bit dicey, 2 years, forget it.
Um, it really depends on the type of job the individual does, the way you've worded the PTRs, whether they're generic. If you've got them in everyone's contracts, you won't be able to enforce them full stop, is pretty much the case law that we've seen. If you've
Really?
got an individual, you've got maybe a sales director, for example, and you've written bespoke PTRs for that person that reference your company and reference other competitors by name, and yes, there are 6 months, then those are going to be likely to be enforceable. If it's just a generic PTRs in everyone's contract, then you may as well save
This
the ink.
is not a good idea, and that's very interesting. Okay, that was great.
No point
6 months.
going.
Has there been any case law on 12 months? Is that we?
It's I'm not an expert, so I don't think so. The advice I know that comes from our employment lawyers is the shorter the better. The shorter time period, the more likely they are to hold up. But it's more, the time period itself isn't normally the deciding factor. It's more about how reasonable and fair are they. So are they reasonable to the individual that they can still work in their specialist field, but also balancing the needs of your business. So it's not necessarily just about timescales, it's more about how well written they are and how bespoke they are.
Yeah, I mean, it's viewed, isn't it, often as a restraint of trade. But equally, I suppose, if those individuals are directors, then presumably they also have a fiduciary duty, even if they're stepping down as a director and moving on to a new position elsewhere. So you can have them on, like, but in general, it feels a little bit like a prenup, doesn't it? It's like it's just as likely to get challenged and probably actually doesn't hold much water.
Yeah, absolutely. And your point about directors is really important there, Stephen, that yes, the fiduciary duty is for directors who are fully directors of a business, not those that are just directors in name, which actually lots of times is what happens, that we've got people with a job title of director, or heads of, or whatever other job titles we've got, but they are in effect still employees, but it's those senior people that could do damage to your business if they move on. So yeah, they need to be bespoke, is the advice. Otherwise you might as well not bother.
And they are definitely upheld. I have my uncle had was upheld across the whole of the UK for a year or 2 years, I think, even
Wow.
as a sort of coach, and that was about 20 years ago.
Mm.
So they are upheld. Yeah, but that's great. Thank you very much.
The other thing about having PTRs in the contract, even if they're realistically not that likely to be enforceable, is actually they might discourage people from that sort of behaviour. And we often see a letter. So if we've got someone who's moved on and we've got a suspicion that they are breaching the terms of their PTRs, a cease and desist letter from a solicitor is often enough to sort of put the wind up them, if that's a phrase I can use, to discourage them from carrying on with whatever activity we don't want them to do. So even if we couldn't necessarily enforce it in a court of law, just having them sometimes is enough to discourage that behaviour. So, okay, so similar thing around pay and benefits. So exactly as I said about contracts earlier, have we got this stuff written down? Are we meeting the minimums? So minimum wage, obviously. Are we making our pension payments as we need to? And bonuses, have we written some rules around bonuses? Because this is an area that catches people out quite regularly. If you've paid bonuses regularly to people, become custom and practice, you then have a bad year, or you choose that you don't want to pay a bonus this year for any reason. But actually, if you've had that custom and practice and there isn't anything in writing that sets out the rules around the bonus scheme, you're opening yourself up to a claim. You're also potentially opening yourself up to a claim if you've got inconsistent application of bonuses. So if certain job roles are eligible for bonus and it's not written out why, it's just what you've always done, and other job roles don't attract bonus, we need to understand why that is, because those are often things that would be brought into a discrimination claim. For example, if the job roles that don't attract bonus are populated in the main by younger employees or populated in the main by female workers, those are going to be grounds that someone's going to use that. We know that the number of employment tribunal claims is going up substantially every single year. I think the last quarter's figures were 23% up on the previous years. So people are making claims, and not having some written guidance around bonus could just open you up, again, encourage someone to make a claim even if they haven't got substantial grounds. So that's not to say don't do bonuses, but that is to say do ideally write some rules around what your bonus scheme looks like and why it's going to be enforceable, who it's going to be applicable for. And if you want it to be non-contractual and you want the right to withdraw it, you need to write that down. This is a non-contractual scheme and we reserve the right to change it at any point. I think often things around bonuses and around pay rises in general, we can feel we're doing a kindness, we're doing a good thing, or we're reacting to industry demands. So we've got to pay our new starter more to attract them. And that means they're then out of kilter with our existing employees. And those are things that we just need to be really mindful of, that could open us up to a complaint, a grievance, and potentially an employment tribunal as well.
If we have discretionary bonus in contracts, but then we give bonuses to other people, but I don't want to say there's no rationale, there's always rationale. Is that an issue? Obviously we're not making it public knowledge to the whole team that other people have got bonuses and some haven't, but as long as the contract is discretionary, can we then pick and choose who gets them and who doesn't? And that's not going to set us up for any problems, is it?
As long as the rationale is objective and non-discriminatory,
okay, then
yes, the risk might come if someone who doesn't get the bonus gets wind that other people have had a bonus, and they come to you and say, well, why didn't I get a bonus? Because is it because I'm junior, I'm young? Is it because I'm female? Is it because I'm part-time? Is it because so you're going to have to then be able to respond with a rationale of why one person got a bonus and they didn't.
Okay, we gifted some people bonuses because they spent 8 weeks abroad for a specific client, and that was obviously, so that's enough rationale then, isn't it, for us to, okay, cool. Awesome, thank you.
Yeah, objective reasons and notes that you've made at the time. The employment lawyers always suggest making contemporaneous notes, so writing it down at the time about, even if it's just an email to yourself or an email to your colleagues at the time to say, these people are going to be paid a bonus because. So it was written at the time, because if someone comes to you later and makes that claim, oh, well, I didn't get a bonus because I'm the only one that's only 21, and then you're going to be scrabbling for that answer, potentially. And if you end up in a tribunal, the notes that were written at the time, those emails time-stamped at the time, are going to be much more powerful defence.
Should I put it in writing to the individuals concerned as well, or is that's not necessary because I've verbally communicated? Okay.
No, I wouldn't say that's necessary.
Okay.
Unless you wanted to. It wouldn't, it's not necessary. As long as you've got that written note somewhere that you know, and whoever, maybe you've moved on, Karen, by the time a claim comes in, does someone
Yeah.
else know why that was done?
Okay.
That's the important part there.
Thank you. That was very helpful.
No worries. Okay. Lots of you will have heard Alistair and I talking about the Worker Protection Act at the back end of last year. The Worker Protection Act is this amendment to the Equality Act that introduces specific duties on employers around sexual harassment. So making sure that you are taking reasonable steps to prevent sexual harassment of your employees by other employees, but also by third parties. So if you've done nothing around the Worker Protection Act yet, I would really strongly encourage you to do that. Look at a risk assessment, try and work out where the risk of sexual harassment might come to any of your employees, and then what can you do to mitigate any of those risks. And again, get that all written down. Make sure your dignity at work and your bullying and harassment policies reference sexual harassment specifically. It's not that sexual harassment is now suddenly more important than any other form of harassment. It's just we have these specific additional duties put on us as employers. So we do need to name what we're doing specifically to prevent sexual harassment, as well as what we're doing to prevent harassment more broadly. The employment EHRC guidance, that's the Human Rights Commission guidance around the Worker Protection Act, says that you should have a bespoke policy, and you should deliver bespoke training to your management team, but also your non-management team, so that they know what constitutes sexual harassment, what to do if they are sexually harassed or witness harassment happening, so that they know who to report to. And we should have various forms of reporting routes. The recommendation is that we consider whether we need anonymous reporting routes as well. We don't know very many organisations that have actually taken that up, but some of you might have access to whistleblowing helplines, and those can actually be really helpful because they will also take a sexual harassment claim as well. So if you haven't done a risk assessment around sexual harassment, if you haven't updated your policy or looked at rolling training out for your teams, then that is something I would suggest you do sooner rather than later. And my rationale for saying that is that we are anecdotally seeing a massive rise in the number of grievances raised within organisations. And lots of those are around harassment. Again, as I said at the start, people are very, very aware of their rights now, and they have different expectations of a working environment than maybe we had in the past. And so we're seeing a phenomenal increase in the number of grievances. I've been in HR for a long time. In the first 15 years, I probably saw a handful of grievances in total. We're now getting clients coming to us at least one a week, asking us to help with grievances. So the change in the last 18 months is phenomenal. If they haven't come your way yet, then fingers crossed they don't. But I wouldn't bank on it. Don't rest on your laurels. Make sure your policies and your reporting lines are all in place so you know what to do if or when a grievance or a complaint around harassment is raised.
Interesting, isn't it? Sorry,
Sorry,
just jumping in, Heidi. I think the anonymous reporting is really important, but it's just a bit tricky as to how to implement it. I was just checking whether we use Breathe HR platform, and it looks like they might offer some sort of anonymous reporting. It's definitely anonymous sort of general reporting, whether there's specific harassment reporting or not, I don't know. Another business I work with, they have implemented that, but they've done it quite technically. They've used proper tech devs to do it. So
what we've been talking to clients is, like I said earlier, the whistleblowing routes. So if any of you have got access, and they're not very expensive, to have a whistleblowing helpline. That's an independent company where anyone can whistleblow to. They can also go to with a harassment complaint. That's not massively expensive, but I do appreciate it is an expense. What we've got some clients have done is put in an option for individuals to be able to email us at Reality HR. So it's not anonymous, but it's outside of their line management route. So it's not going to their line manager. That's a possibility. Do you have someone independent that they could go to? Maybe it's a non-exec director on the board or something like that. So someone who isn't their direct line management. And the other thing that we are seeing companies doing quite regularly is looking at surveys. So you might well have done engagement surveys in the past. We use a platform called Water. We use it internally. We recommend it to clients. We use a platform called Water. It's a daily question, or you can fill them in whenever you want. But Water has a anonymous feedback section built into it. So any comments that are left through the Water app, the leadership team can see with absolutely no way of finding out who they've come from. So there are some ways that we can build this into our existing processes if you're doing things like engagement surveys. And that's on that point, if you do an engagement survey, it's worth considering, do you want to put in a question about have you ever witnessed or been victim of harassment, so that you've got a bit of a benchmark level, so what are people saying about working in your organisation? Also making sure you're asking that question at exit interviews. So there's quite a lot we can do around Worker Protection Act immediately, and that doesn't have to be particularly expensive. There are lots of things that we can do to build our evidence to show we've taken reasonable steps, but it is what's reasonable for the size of your organisation.
How did you spell that? Is it Water?
Water, yeah, WOTTER.
Yeah, that sounds interesting. Okay, great, thanks.
I think this piece about harassment is going to become even more important. I'm going to move on very quickly now, but we will see a bit more. There is extension coming to the existing harassment protections for employees. So don't park this one. We haven't got any case law yet because we've got a 3-year delay in the employment tribunals. But as I say, the evidence, our anecdotal evidence, is that grievances are going up, and some of those grievances will, no doubt, result in employment tribunals when they get there. We'll keep you up to date once we know a bit more about the case law that's happening. Okay, so I guess as a sort of summing up of what we need to be doing right now is making sure that you are confident, and anyone who's in a line management position is confident of knowing what's in your contracts, knowing what's in your policies, and knowing that those are up to date, but also knowing that you've got a route to take advice if you get questions that you don't know the answer to. So do you have a route for HR advice? As Stephen said, we've been Pimento members for a number of years. All our contact details are in the portal, and we're very happy to offer initial conversations with any Pimento members on a complimentary basis, and then work out what you need from us. So what's happening? What's changing? Okay, well, you'll have been, I'm sure, aware of all the Employment Rights Bill talk in the newspapers, across social media. There's been quite a lot of information shared so far about the Employment Rights Bill, and we're nearly there. It's final consideration of amendments. We're expecting royal assent imminently, so we're going to see some things happen quite soon. I'll talk through the headline changes. If anyone's got any questions, please feel free to ask, but I won't go into too much detail, and then I'll give you the timescales. And what I hope we've done so far is talk you through those stages in your checklist that gives you some ideas about what you might need to go and look into, and then we'll come back to what we can do, to be prepared. Really, that's the next step, is getting your current status right, and then preparing for what's coming. Before I move on, I've just seen a question pop into the chat. David's asked, can you insure against any of the risks? You can insure against employment tribunals. Some of the HR advisors provide insurance policies that mean if you do end up in a tribunal, they would cover your costs and any award to individuals. It's not a practice that we use because we believe that every organisation, every agency, every business has got a different appetite for risk, and we would rather talk to you about what you would like to do. how much risk you are open to. Whereas if you do have one of those insurance policies, then of course they make you do a very, very, very detailed process if you want to exit someone or make redundancies, for example. You're going into the real minutiae of all those process steps because that's their requirements. Whereas we'll be able to, our view, with over 20 years in HR as a consultancy, is that actually that doesn't always work for businesses. Some of you may be more willing to take a little bit of a risk and do it a bit quicker, and settle if you need to, or just, you know, take that risk that the individual wouldn't make a claim. So yes, the options are out there, David. I can't name anyone off the top of my head because we don't work with anyone that does that, but there are offerings that give you that insurance. Okie doke, let's move on into the Employment Rights Bill. So the main headlines, you'll have seen all of these, I'm sure, across the media. Unfair dismissal becoming a day one right. At the moment, individuals can't make a claim for unfair dismissal until they have 2 years service. Well, it's actually a year and 51 weeks. But until we've got 2 years service, the suggestion is going to be this becomes a day one right, but there will be a initial period of employment, which is a probation period by another name. It's likely to be 9 months. The Lords made some big suggestions, big amendments to the Employment Rights Bill on this topic, and we think the government are going to throw those Lords amendments out and stick with what they want, which is this 9 months period of employment. What that really means for you guys is that when you're recruiting individuals, you need to make sure that you are making the most of that 9-month period. So are you setting really clear objectives at induction? Are you using probation reviews throughout that 9-month period? Because once that 9 months ticks over, that person then automatically has those full employment rights and can make an unfair dismissal claim should they want to. We're expecting there to be a sort of a lighter touch process for dismissing during that 9-month process. At the moment, I'm sure you're all aware, during the first 2 years of employment, you don't have to follow any process to dismiss someone. You can literally call them into your office today and tell them that you're giving them their notice and that they should go home now and they're sacked. As long as it's not a discriminatory reason for that. But with this, we're expecting a light touch process. So understanding what that's going to look like and then making sure any managers involved in that decision-making process need to know about those. But the biggest advice we can give is make sure that you use probation reviews, set objectives, use probation reviews, because that's going to be your and what we've been saying to managers for the last 12 months, get in the practice of doing it, because it's going to be essential once this change comes in. And it isn't coming until, I think it's 2027, but this is what I'm saying, get these activities and practices in place so we're used to using it, no matter what. Okay, the other things that are the main headlines: statutory sick pay is being extended to reduce the lower earnings limit to capture more people. There'll be a new rate of SSP, so it's going to be slightly higher. It's going to be 80%, we think, of average weekly earnings. We are also going to see the removal of the waiting days. So at the moment, or in the past, you didn't get paid any statutory sick pay for the first 3 days of a sickness absence. You only got paid from day 4. That's going to change from day 1. So what that means is there's going to be more people eligible for SSP because the lower earnings limit's being reduced, and people, those that are on statutory sick pay, are going to be able to claim that from day 1. Now, if you have a contractual sick pay policy in place, if you pay over and above statutory sick pay, you might just want to go back and review that and make sure what reference you make in your contracts or your policies to statutory sick pay. It won't necessarily mean you have to change anything in your policies. If you're paying company sick pay, let's say you pay 2 weeks sick pay for people, once they've taken all that sick pay, they're going to then be entitled to statutory sick, and so it's just being mindful that there won't be those waiting days, and the lower earnings limit won't be there. So The other thing that we're just thinking about with sick pay is actually if people are going to be paid from day one, and this depends on the culture in your organisation, but you've probably got a situation at the moment where people don't go off sick because they know they're not going to be paid for the first 3 days if you're only a statutory sick only organisation. What this does mean is that actually you might see absence increase. Your absence rates might increase when people know they're going to get at least some statutory sick pay from day one. So it's worth looking now again at your process around reporting for sickness and tracking sickness. So I would suggest if you're going to introduce some sort of tracking so you can see how many days off people have had, you would want to do that sooner rather than later as well. That doesn't mean you're necessarily going to go in totally heavy-handed. We do work with some organisations who are very, very heavy-handed. I worked for a large retailer before I moved into reality HR, and they're very strict. You take three absences in a 12-month period and you automatically get a disciplinary warning. That feels like a sort of a bit of a sledgehammer approach to me. Isn't necessarily what we're suggesting for all of you guys, but it would be worth knowing your baseline of absence right now so that you can then measure if there is much change once the SSP changes happen, so that you can get a gauge of what's the norm in your organisation. And for those of you that pay company sick pay already, please ignore all of that. It's not going to be relevant to you. The next biggie, 0 hours and flexible working. Well, these are two separate things, actually. So 0 hours, people on casual contracts, bank staff, casual staff, agency workers are all going to be captured under this right to have guaranteed hours. So obviously the purpose of a 0 hours contract is that you can flex their hours up and down week by week as you need them. Which is great for flexibility for the employer. It can be great for some employees, really like that level of flexibility as well. But I think what we've known that the government have been uncomfortable with this for a long time, they call it exploitative. And some employers do exploit this opportunity. So we're going to see this requirement that we offer people guaranteed hours. They can opt out of it. They don't have to take the guaranteed hours. They don't have to accept that, but we are going to see that we have to make that offer. So if you do use a lot of casual staff, bank staff, 0 hours, it's worth getting some advice now about what that might look like for those individuals, because you've still got time. The guaranteed hours for people is only going to apply to those that do a set number of hours over a set number of weeks. So this is a very cynical approach. Please don't repeat this too loudly in front of your staff. But if you did want to change that, you've still got time so that you wouldn't be captured by the guaranteed hours clause. And then the second part of this point is about jobs becoming flexible. Well, we all know that at the moment, anyone can make a flexible working request. And we have 8 reasons set out in the law that we can turn those flexible working requests down. That isn't changing. It's more of a mindset shift that the government are asking employers to make, that all jobs will be deemed to be flexible unless we can use one of those 8 reasons to explain why that particular one can't be done flexibly. I think that in a lot of roles, location, working from home is the request that we see, and sometimes that's really obvious. If you're a supermarket, clearly someone can't work from home because the till isn't in their front room, so that's obviously not a flexible role. But where the lines are a little bit more blurred, in office-based roles, it's going to be around location of work, but also around hours of work. So do people want to work shorter hours, part-time, split their time between the morning and the evening, or whatever it is that people are asking? We're going to have to be able to have a more robust response to say why their job in particular isn't flexible. I don't think it's going to need a change to your policies as yet. It's just an awareness that the mindset shift here is happening. Okay, and just very quickly then, the time limit of making a tribunal claim is going to be extended up to 6 months. At the moment, individuals have 3 months from either a date of dismissal, if they're looking at an unfair dismissal claim, or 3 months from the date of the alleged discrimination to make a claim. We've got about a 3-year backlog in the employment tribunal system. The government are hoping that by extending this to 6 months, that gives people more time to do early conciliation So finding an agreement and a settlement, and therefore it not needing to go to tribunal. They're trying to take the pressure off the tribunal system. What that means for us in practice as employers is when we have had a particularly prickly or contentious exit from somebody, we're going to be sat on the edge of our seats for 6 months instead of 3 months. You know, on that waiting, will their employment tribunal claim come? Those are the main headlines. There are a couple of other things that are going to change that I'll just touch on very, very briefly. They're quite specific, so they won't necessarily apply to everyone. It depends on the nature of your work. The Fair Work Agency is going to apply to all of us. This creation of this Fair Work Agency is going to be bringing together all enforcement of statutory payments, so things like national minimum wage, statutory sick pay, holiday pay. At the moment, HMRC enforce any national minimum wage underpayments, for example, but this is all going to be brought together into this one agency. And interestingly, the Fair Work Agency is going to be self-funding. So when they do enforce any payment, you know, if anyone comes in with an underpayment and they enforce that payment on you as an employer, they are able to add a fine of up to 200% of the award, which will fund the agency. The other thing that we're not quite sure how it's going to work yet around the Fair Work Agency is they're going to be able to bring employment tribunal proceedings on behalf of employees who haven't themselves individually made an employment tribunal claim. The lawyers are really nervous about this, so we'll see what happens when we get to the actual law. At the moment, we're still, as we know, we're still in the discussion stages. So that's going to be really interesting to see what happens there. We've got lots of extensions I mentioned already to family-friendly rights, extension of rights around maternity. So if you've been on maternity leave, you're going to be protected from redundancy and dismissal for longer than you are currently. We're going to see extensions to bereavement leave. So parents who very sadly lose a young child or a late loss of pregnancy, there's going to be extensions to the bereavement leave requirements. We're going to see extensions to the collective redundancy consultation. At the moment, if you're looking to make more than 20 redundancies on a particular site, you have to move into collective redundancy. There's lots of discussion about whether this is now going to be, if you're looking to make 20 redundancies across any of your sites. So we don't know exactly what that's going to look like, but it's going to mean that we need to be really mindful, particularly for organisations that have lots of different sites. We're going to have to be keeping a central record to make sure we're not triggering that collective redundancy consultation requirement. And the other thing that's going to be happening is an awful lot of change around trade union recognition, easing balloting rules, expanding access of trade unions to come onto sites, easing the collective bargaining requirements. So lots of change expected there. Obviously, the Labour government are looking to make give trade unions back some of the power that's been eroded by various Conservative legislation over the last 14 years. I've got headlines here. Fire and rehire I mentioned earlier. We don't know of many organisations that actually use fire and rehire as a process, but what we do know is that lots of organisations do want to change terms and conditions and find agreement before we get to fire and rehire. Fire and rehire is like the nuclear option. If you've tried every different type of route of consulting on changes, there's going to be very, very limited situations where you'll actually be allowed to fire and then re-engage those individuals. We've already had guidance come out last year and the year before to try and prevent it happening too much, but now it's going to be written into the law. And we're expecting something around the right to switch off. It's not going to be actually in the Employment Rights Bill, but we are expecting some guidance or a statutory instrument of some sort to talk about the right to switch off, which you've probably come across from various other countries. Australia introduced it fairly recently. Lots of European countries have this right to switch off. So that is coming.
Very interesting.
A quick question from David in the chat. Is there any requirement for menopause policies? Well, yes, menopause, the requirement will be, we think, to have a menopause plan, the menopause action plan, to talk about what you're going to do to reduce the impact of menopause on employees and make sure employees affected by menopause are supported. That's going to come in voluntarily from April 2026, and actually in the law from April 2027, if having those policies. But we believe they're going to only be a legal requirement for bigger organisations, those with over 250 employees or that have a certain level of turnover. I would suggest it's good practice for us all to be thinking about a menopause policy. You may not be in a position to do so as yet, but I think that it's again a topic that's hitting the headlines. It's a hot potato topic, and to be proactive with it might be really helpful from an engagement perspective, so that your employees know that you care about it and you're looking into it. So there we go. We've got some of the dates on here around the timeline of what's happening. I'm really conscious of the time this morning. This is setting out the roadmap set out by the government about when we're expecting each of these changes to come in. But I think, as I said earlier, the big things we can be doing right now are reviewing our handbook and our contracts to make sure they're fit for purpose, reviewing the number of casual staff that we employ or that we engage and how we engage with them. That's a big thing to look at now. Make sure you have looked at probation and you're starting to get into the habit of using those probation reviews. Those, I think, are the real things that we can do to be prepared. And the whole piece around sexual harassment, the Worker Protection Act. If you haven't done your risk assessment yet, that's my biggest piece of advice, because that is where the most substantial fines are likely to come from should you end up in a tribunal. So with half a minute to spare, here's a bit of a summary.
That's brilliant. That's really
get
helpful.
In touch. Thanks.
Thank you. We'll share this presentation with everybody, so you've got the contact details, and I think a couple of people, Will Walsh, for example, wants to follow up with you, Heidi, and have a chat.
Yeah.
Lot of information, obviously, to digest, I think, in this session, and obviously lots of serious and important things that we takeaways we need to take with us all today. For those who haven't already, just a couple of quick reminders of events and activities that we have coming up over the next few weeks. It's a busy period for everybody, I know, as we move into the autumn, but Marketing Spice Live, which is our client and agency event, is on 24th September. It's on the future of marketing to schools and universities. We will make sure the link for that is shown in a second, but we'll send it in the note that follows up this. And then the big one, if you haven't already booked, is the Festival of New Business. It's on the 7th of October. It's in London at One Birdcage Walk. It is unfortunately a ticketed event, but it's extremely good value for money, and we have a few seats left. If you'd like to join us, if you're involved in actually trying to generate new business for your agency, consultancy, or pro service business, this is the event to come to. We'd love to see you there. Once again, thank you for joining us, and Heidi, thank you for putting all this together. It was very, very helpful and insightful, and food for thought. And I'll be catching up with my own HR head, Isabel, later on to make sure that we are fully compliant and on the case. So without further ado, it's now midday. Thank you very much indeed, and I look forward to seeing you all very soon. Goodbye.